The Supreme Court chamber fell completely silent. Chief Justice John Roberts, known for his stoic demeanor and strict control of the courtroom, suddenly removed his reading glasses and leaned forward in his chair. His eyes fixed on Congresswoman Jasmine Crockett, who stood calmly at the podium. What had begun as a routine hearing on voting rights was about to become a moment that legal experts would discuss for decades. Congresswoman Crockett, the Chief Justice, said, his voice carrying clearly through the hushed courtroom, "I must say I've rarely encountered such clarity of thought under such intense questioning." The gallery exchanged surprised glances. Chief Justice Roberts was not known for offering compliments during oral arguments. But what happened next left even veteran court reporters reaching for their notepads. The Chief Justice nodded respectfully to Crockett, a gesture that spoke volumes in the formal setting of America's highest court. In that moment, a first-term Congresswoman from Texas had earned something few advocates ever receive: the unmistakable respect of the nation's top jurist. If you want to understand exactly what Congresswoman Crockett said that earned such unprecedented recognition from Chief Justice Roberts and the lasting impact of this remarkable courtroom moment, hit the like button and subscribe to our channel for more in-depth coverage of the pivotal moments shaping America's legal landscape. To appreciate the extraordinary nature of this courtroom exchange, we need to understand the two remarkable individuals at its center and the high-stakes case that brought them face to face. Chief Justice John Roberts has served as the head of the Supreme Court since 2005. Born in Buffalo, New York in 1955, Roberts built an impeccable legal reputation long before joining the court. After graduating from Harvard Law School, he clerked for then Associate Justice William Rehnquist, worked in the Reagan administration, and became one of the nation's most respected appellate attorneys, arguing 39 cases before the Supreme Court. As Chief Justice, Roberts has been known for his careful, methodical approach to constitutional questions and his deep concern for the court's institutional reputation. Court observers have long noted his discomfort with heated rhetoric and his preference for narrow, technically precise legal reasoning. Though appointed by President George W. Bush, Roberts has occasionally broken with conservative expectations, most notably in cases involving the Affordable Care Act. Roberts views himself as a guardian of the court's legitimacy, explained constitutional scholar Lawrence Tribe. He's extraordinarily careful about maintaining the dignity of proceedings and rarely displays strong emotion from the bench. Across the courtroom stood Congresswoman Jasmine Crockett, representing Texas's 30th Congressional District since 2023. But Crockett's path to Congress wasn't typical. Before entering politics, she had built a formidable reputation as a civil rights attorney, handling numerous voting rights cases throughout the South. Born to working-class parents in St. Louis, her father a postal worker and her mother a nurse, Crockett witnessed firsthand how voting restrictions affected her community. After earning scholarships to Rhodes College and the University of Houston Law Center, she dedicated her legal career to voting rights litigation, particularly in communities with long histories of disenfranchisement. What makes Crockett especially effective is her combination of deep legal knowledge and personal understanding of the communities affected by these laws, noted Richard Hansen, a voting rights expert at UC Irvine. She doesn't just know the case law, she knows the human impact. The case before the court, Henderson County Election Commission versus United States, challenged a state law that had closed over 200 polling locations in predominantly minority neighborhoods while claiming to optimize electoral efficiency. Though the law never explicitly mentioned race, its implementation had resulted in minority voters having to travel, on average, 5 times farther than white voters to cast their ballots. Lower courts had split on whether the law violated Section 2 of the Voting Rights Act, with a circuit court ultimately finding insufficient evidence of discriminatory intent. The Supreme Court agreed to hear the case given its potential to reshape voting rights jurisprudence nationwide. What do you think about laws that make it harder for certain communities to vote even when they don't explicitly mention race? Have you or your family ever experienced difficulties accessing polling places? Share your experiences in the comments below. Your personal stories help illustrate why these constitutional questions matter to everyday Americans. The morning of oral arguments, tension filled the Supreme Court chamber. The gallery was packed with journalists, legal observers, civil rights leaders, and state officials. Crockett entered wearing a simple navy suit, carrying only a slim binder of materials. Unlike many advocates who brought stacks of reference materials, Crockett's preparation was evident in her focused presence and calm demeanor. Chief Justice Roberts opened the questioning. Congresswoman Crockett, your brief argues that this polling place formula violates Section 2 of the Voting Rights Act. Despite containing no explicit racial classifications, how do you establish discriminatory intent when the text appears facially neutral? Crockett approached this critical question with remarkable composure. Mr. Chief Justice, the court's decision in Arlington Heights provides the framework for identifying discriminatory intent behind facially neutral laws. We must examine the historical background, sequence of events, departures from normal procedure, and the law's practical impact. She continued without consulting her notes. In this case, all four factors point decisively toward discriminatory intent. The state's own pre-implementation analysis predicted these closures would affect minority voters at 3 times the rate of non-minority voters. Alternative plans that would have achieved the same efficiency goals without such severe, disparate impact were presented and rejected without explanation. Justice Samuel Alito appeared skeptical. Congresswoman, correlation is not causation. Couldn't these disparities result from population density or other neutral factors unrelated to race? Justice Alito, I agree that correlation alone would be insufficient, Crockett replied, surprising him with her immediate concurrence. That's why we've presented evidence beyond statistical disparity. She removed a single document from her binder. This internal memo from the Secretary of State's office, obtained during discovery, explicitly acknowledges that the formula would significantly reduce turnout in areas that historically vote Democratic, given the well-established correlation between race and partisan preference in this state, a correlation documented in multiple federal court decisions. This statement provides compelling evidence of discriminatory intent. Justice Elena Kagan jumped in. Counsel for the state argues that budget constraints justify these closures. How do you respond? Crockett's response was measured but forceful. Justice Kagan, the record shows the state simultaneously allocated $4.2 million for new polling locations in predominantly white rural areas while claiming budget constraints required closures in minority communities. This contradicts their budget justification and further supports an inference of discriminatory intent. Justice Neil Gorsuch, known for his textualist approach, pressed harder. Congresswoman, the text of the law itself contains nothing about race. Are you asking us to look beyond the statutory language to infer intent? Doesn't that conflict with our textualist principles? Justice Gorsuch, Crockett responded, textualism doesn't require willful blindness to context. In Village of Arlington Heights, this court recognized that even facially neutral laws may be an obvious pretext for racial discrimination. The text matters greatly. But this court has consistently recognized that the Constitution prohibits sophisticated as well as simple-minded modes of discrimination. Gorsuch followed up with increasing intensity. But where do we draw the line? How do we determine when a disparate impact crosses into discriminatory intent without simply substituting judicial preferences for legislative judgment? Crockett didn't flinch. The line is drawn by the evidence. Justice Gorsuch. Here we have contemporaneous statements from officials, rejected alternatives with less disparate impact, and procedural irregularities in the law's adoption. These aren't subjective judicial preferences. They're objective indicators. This court has long recognized as evidence of discriminatory intent. Justice Brett Kavanaugh shifted the focus. Let's talk remedies. If we were to find a Section 2 violation, what's the appropriate remedy here? Wouldn't we be engaging in judicial policymaking by dictating polling place locations? Not at all. Justice Kavanaugh. Crockett countered. The remedy would simply require the state to implement a polling place formula that doesn't impose disproportionate burdens on minority voters. The state would maintain full discretion in how to achieve that constitutional requirement. Courts have managed similar remedies for decades without engaging in polysim for over 40 minutes. The questioning continued at this intense pace. Each justice probed for weaknesses. But Crockett responded with a combination of constitutional principles, case precedents, and hard data that seemed to anticipate every challenge. Justice Amy Coney Barrett asked about historical context. Congresswoman, how much weight should we give to a historical discrimination in a state when evaluating a modern, facially neutral law? At what point does that history become too attenuated to be relevant? Justice Barrett, history matters most when it's still producing measurable effects today, Crockett explained. In this case, we've documented how historical housing segregation in this state directly correlates with current residential patterns, which in turn affects which communities bear the burden of these polling place closures. This isn't distant history. It's ongoing causation. Then came the exchange that would make legal history. Chief Justice Roberts, who had been unusually engaged throughout the argument, posed a hypothetical that even experienced advocates might have found challenging. Congresswoman Crockett, let's consider a jurisdiction that adopts a race-neutral criterion for polling place allocation. Say one polling place per 5,000 registered voters. If this formula results in fewer polling places in minority neighborhoods because of lower voter registration rates stemming from historical discrimination, would that trigger strict scrutiny under your theory? The courtroom tensed. Roberts' hypotheticals were known for exposing logical weaknesses in advocates' positions. This question required navigating multiple complex doctrines while maintaining focus on practical impact. Crockett paused thoughtfully before answering. Chief Justice Roberts, this hypothetical highlights what scholars have called second-generation voting discrimination, policies that leverage known social patterns to produce racially discriminatory outcomes while maintaining plausible deniability. She continued with remarkable precision. Under Arlington Heights and Brnovich, I would examine whether the jurisdiction knew or should have known about this disparity before implementation. If officials were informed that their facially neutral policy would produce severe racial disparities yet proceeded anyway, particularly if less discriminatory alternatives were available, we can infer discriminatory intent sufficient to trigger heightened scrutiny. Roberts pressed further. But where do we draw the line? Couldn't virtually any election administration decision be challenged if it produces any statistical disparity? It was this moment that showcased Crockett's exceptional ability to balance legal precision with practical wisdom. The line, Mr. Chief Justice, lies in the Arlington Heights factors properly applied, she responded. Not every disparate impact reflects discriminatory intent. Some truly are unforeseeable or unavoidable consequences of legitimate policy. The Constitution does not guarantee equal outcomes in every instance. She paused briefly, then continued with growing conviction. But when a state is specifically informed that its chosen method will severely burden minority citizens' fundamental right to vote, when less discriminatory alternatives exist to achieve legitimate administrative goals, and when the state rejects those alternatives without meaningful justification, particularly against a backdrop of historical discrimination, the Constitution cannot remain silent. As Crockett spoke, the courtroom remained completely still. Even justices who clearly disagreed with her position appeared engaged by her reasoning. The 15th Amendment's prohibition on denying or abridging the right to vote on account of race wasn't limited to explicit racial classifications. She continued, the framers understood that voting rights could be undermined through indirect means just as effectively as through direct prohibitions. That's why they chose the broad language of denied or abridged rather than narrower terms. Crockett concluded with quiet force. When sophisticated methods achieve the same discriminatory results as the poll taxes and literacy tests of the past, they must meet the same constitutional fate. Otherwise, We reduce the 15th Amendment to a mere formalism that prohibits only the most obvious forms of discrimination, while permitting their functional equivalents. Justice Clarence Thomas, who rarely speaks during oral arguments, surprised the courtroom by asking a direct question. Congresswoman Crockett, many of these communities had functioning polling places for decades. What specific evidence suggests that their closure now, as part of a statewide efficiency plan, represents intentional discrimination rather than neutral administration? Crockett turned to address Justice Thomas directly. Justice Thomas, 3 pieces of evidence are particularly compelling. First, the state's own simulation data showed these closures would affect minority voters at dramatically higher rates than white voters. Second, the Planning Commission minutes reveal that when this disparate impact was pointed out, the chairman responded, "We can't be responsible for who chooses to vote." And third, alternative plans that would have achieved similar efficiency goals without such severe disparate impacts were presented and rejected without substantive explanation, she added. Perhaps most tellingly, Justice Thomas, the communities most affected by these closures had seen record minority turnout in the previous 2 election cycles. The timing of these specific closures immediately following historic minority participation provides strong circumstantial evidence of discriminatory intent under this court's precedents. Thomas nodded slightly, his expression inscrutable but attentive. Justice Sonia Sotomayor followed up. Congresswoman, how do we balance the state's legitimate interest in election administration efficiency against the potential burden on minority voters? Justice Stoyer, efficiency and equal access aren't mutually exclusive. Crockett responded. The record shows that alternative Plan C would have achieved 92% of the cost savings while reducing the disparate impact by over 70%. When such alternatives exist, states can't legitimately claim that discrimination is the price of efficiency. As she finished speaking, Chief Justice Roberts sat motionless, his expression thoughtful, the typical rapid-fire questioning that characterized Supreme Court arguments had given way to a moment of reflection that was rare in the nation's highest court. The state solicitor general approached the podium for rebuttal, but it was immediately clear that the momentum had shifted. Justice after justice pressed him on points Crockett had raised, particularly regarding the rejected alternatives and the internal communications about partisan impact. If your state knew these closures would disproportionately affect minority voters and had alternative plans that would achieve the same efficiency without that impact, why were those alternatives rejected? Justice Stoyer asked directly. The Solicitor General struggled to provide a compelling answer, repeatedly returning to the law's facial neutrality. The statute contains no racial classifications. He insisted courts should be extremely cautious about inferring discriminatory intent from disparate impact alone. Justice Kagan interjected, "But we're not talking about disparate impact alone, are we?" Congresswoman Crockett presented internal memos acknowledging the racial impact, testimony about rejected alternatives, and procedural irregularities in the law's adoption. How do you respond to that specific evidence? Those internal communications were preliminary drafts. Your Honor, the Solicitor General replied, his voice less confident than before. They don't represent the legislator's final thinking on the matter. But they do demonstrate awareness of the likely impact, Justice Barrett noted. Doesn't that awareness become legally significant under Arlington Heights? The Solicitor General shifted his approach. Your Honors, even if the court finds a Section 2 violation here, the proper remedy would be limited to the specific communities with demonstrated disparate impact, not invalidation of the entire state formula. Chief Justice Roberts, typically deferential to state officials, intervened with unexpected directness. Counsel, you haven't addressed Congresswoman Crockett's evidence that your state was explicitly warned about the disparate impact, yet proceeded without considering less discriminatory alternatives. How do you reconcile that with your claim that any disparate impact was unintentional? Mr. Chief Justice, the Solicitor General responded, visibly flustered. Election administration requires difficult trade-offs. The legislature weighed many factors beyond what's reflected in the record before this court, including which voters would find it more difficult to cast ballots. Justice Kavanaugh asked pointedly. "No, Your Honor, of course not," the Solicitor General insisted. The formula was based purely on administrative efficiency and cost considerations. Yet Alternative Plan C, which Congresswoman Crockett referenced, would have achieved similar efficiency with significantly less disparate impact. Justice Gorsuch noted. Why wasn't that plan adopted if the goal was truly efficiency rather than reducing turnout in certain communities? The Solicitor General fumbled through his binder. I don't have the specific details on Alternative Plan C before me, Your Honor, as the rebuttal faltered. Even justices expected to be sympathetic to the state's position were asking increasingly pointed questions. The Solicitor General, who had entered the courtroom with confident assurance, now seemed to be struggling to maintain his arguments against the framework Crockett had established. Justice Thomas, who had been attentive throughout, asked what would prove to be the defining question of the rebuttal. Counsel, if we accept your argument that only explicit racial classifications trigger constitutional scrutiny, aren't we creating a roadmap for states to circumvent the 15th Amendment? Through facially neutral laws with known discriminatory effects. The courtroom fell silent. Coming from the court's most conservative member, this question signaled a profound shift in the argument's momentum. Justice Thomas, the Solicitor General, began cautiously. The court has always required evidence of discriminatory intent, not merely disparate impact. And isn't evidence precisely what Congresswoman Crockett has presented today? Thomas replied, internal communications acknowledging racial impact, rejected alternatives with less discriminatory effect, and historical context suggesting a pattern. The Solicitor General had no effective response. When Crockett rose for her brief final response, the courtroom fell completely silent once again. The question before this court is whether our Constitution permits states to do indirectly what they are forbidden to do directly. She began, the evidence shows the state knew their formula would severely burden minority voters, rejected less discriminatory alternatives, and proceeded anyway. She continued with quiet conviction. Throughout our nation's history, the right to vote has faced repeated challenges, from property requirements and poll taxes to literacy tests, and now, sophisticated administrative barriers. What changes is not the effect but the method. This case isn't about whether states can pursue legitimate efficiency in election administration. Of course they can. The question is whether they must do so in ways that don't predictably and disproportionately burden minority voters' fundamental constitutional rights. She closed with measured conviction. The 15th Amendment's promise wasn't merely a prohibition on explicit racial barriers. It was a positive guarantee that voting rights would be equally available to all Americans in practice, not just in theory. The voters in my district and throughout the affected state are simply asking this court to give meaning to that constitutional promise. As she returned to her seat, Chief Justice Roberts removed his glasses and set them down deliberately. Looking directly at Crockett, he spoke the words that would be quoted in constitutional law textbooks for years to come. "Congresswoman Crockett," he said, his voice carrying clearly, "I must say I've rarely encountered such clarity of thought under such intense questioning. While the court will of course reserve judgment until our opinion is issued, your presentation today has been a model of constitutional advocacy." The statement hung in the air like a thunderclap. Supreme Court justices simply did not offer such direct praise during oral arguments. The court's strict decorum typically prevented any display of personal opinion until written decisions were issued. Crockett, momentarily surprised by this unprecedented break with protocol, quickly composed herself. "Thank you, Mr. Chief Justice," she replied with characteristic dignity. "While I appreciate your words, what truly matters isn't my presentation, but whether this court will protect the fundamental right of every citizen to cast a meaningful ballot without discriminatory barriers. The 1.7 million Americans affected by these polling place closures aren't concerned with legal rhetoric. They simply want their constitutional right to vote to be respected and preserved. It was this response, redirecting attention from personal praise to the constitutional principles at stake, that triggered Roberts' remarkable gesture of respect. The Chief Justice nodded deliberately to Crockett, a small but profound, cool acknowledgement that spoke volumes in the formal setting of the Supreme Court. The Chief Justice then turned to the other justices, his expression thoughtful. "I believe we've heard thorough arguments from both sides today. This case presents profound questions about our constitutional commitment to equal voting rights and the proper role of this court in safeguarding those rights." Court observers with decades of experience exchanged astonished glances. Reporters furiously scribbled notes. In the gallery, civil rights veterans who had witnessed countless voting rights arguments blinked back tears. This wasn't just another Supreme Court argument. It was a moment when the nation's highest court acknowledged something essential about our constitutional tradition, that its greatest promise lies not in abstract principles, but in ensuring those principles protect the rights of every American in their daily lives. The impact of that extraordinary Supreme Court confrontation between Chief Justice Roberts and Congresswoman Crockett rippled through American jurisprudence and public consciousness. As Crockett descended the marble steps of the court building, reporters swarmed around her. "Congresswoman, what does it mean to receive such unprecedented recognition from the Chief Justice?" One journalist called out. "Today wasn't about any individual lawyer or justice," Crockett responded, maintaining the same principled focus she had shown inside. "It was about whether our Constitution's promises extend to every citizen, regardless of race or neighborhood. The true victory will come only if this case helps secure equal voting rights for all Americans." Meanwhile, inside the court building, Chief Justice Roberts returned to his chambers, visibly moved by the morning's events. According to a clerk who later shared the story anonymously for a profile in The New Yorker, Roberts sat at his desk for several minutes in silent reflection before speaking. "In all my years on the bench," he reportedly said, "I've never heard someone articulate so perfectly what the Constitution's promises should mean in practice. Sometimes it takes a fresh voice to remind us of our deepest commitments." The story dominated legal news for weeks. Constitutional scholars debated the significance of Roberts' unprecedented acknowledgement and what it might signal about the court's direction on voting rights. Harvard law professor Lawrence Tribe commented, "In my 50 years teaching constitutional law, I've never seen anything like this. The Chief Justice's gesture transcends normal court protocols and suggests a profound recognition that Congresswoman Crockett's argument captured something essential about our constitutional tradition." 8 weeks later, the Supreme Court issued its decision in Henderson County Election Commission versus United States, in a surprising 6-3 ruling with Chief Justice Roberts writing for the majority. The court struck down the state's polling place allocation formula. "When facially neutral voting regulations produce severe disparate impacts along racial lines," Roberts wrote, "courts must conduct a searching review of both circumstantial and direct evidence of discriminatory purpose. The fact that a law does not explicitly mention race does not immunize it from constitutional scrutiny when the evidence demonstrates that less discriminatory alternatives were available and rejected without sufficient justification." The opinion directly quoted Crockett's argument as counsel for respondents aptly observed during oral argument. "When sophisticated methods achieve the same discriminatory results as the poll taxes and literacy tests of the past, they must meet the same constitutional fate. This principle guides our analysis today for the voters in Congresswoman Crockett's district and throughout the affected state." The impact was immediate and meaningful. The court ordered the state to restore polling places in affected communities and develop a new allocation system that ensured equal voting access for all citizens. When the next election arrived, voter turnout in previously affected areas increased by 37% compared to the previous election. Citizens who had previously faced hours-long journeys to cast their ballots now found accessible polling locations in their communities. The Henderson County decision became a touchstone in voting rights jurisprudence, cited by courts across the country examining facially neutral election laws with disparate impacts. State legislators increasingly began to incorporate disparate impact analysis into their election administration planning, often inviting civil rights experts to review proposed changes before implementation. For Crockett, the Supreme Court victory affirmed her approach to constitutional advocacy, one that combined rigorous legal analysis with a deep understanding of how laws affect real communities. She continued her work in Congress with renewed purpose, focusing on legislation that would codify and strengthen the principles articulated in the Henderson County case. What made Congresswoman Crockett's advocacy so powerful? Noted Yale law professor Heather Gerken was her ability to bridge constitutional theory and lived experience. She didn't just argue abstract legal principles. She showed the court exactly how those principles translate into either protection or hardship for actual citizens. Perhaps the most unexpected outcome was the special relationship that developed between Chief Justice Roberts and Congresswoman Crockett. Despite their different jurisprudent philosophies, they found common ground in their commitment to constitutional principles and institutional integrity. At Georgetown Law's annual Constitutional Law Symposium the following year, they appeared together in a rare joint interview moderated by Jeffrey Rosen of the National Constitution Center. What struck me about Congresswoman Crockett's argument? Roberts explained to the packed auditorium was not just its legal precision, but its fidelity to the Constitution's deepest purpose, ensuring that our fundamental rights are protected in practice, not just in theory. Good advocacy illuminates the path to justice, even when justices might initially see the constitutional landscape differently. Crockett nodded thoughtfully. And what I appreciated about the Chief Justice's approach? She responded was his willingness to engage seriously with evidence, even when it might lead to conclusions different from his initial inclinations. That intellectual honesty is essential to constitutional interpretation that truly serves the American people. The Henderson County case reminded Americans that our democratic institutions can still function as intended when principled advocates present compelling evidence and thoughtful jurists engage with that evidence in good faith. It demonstrated that despite our polarized politics, constitutional principles still have the power to transcend partisan divisions when properly articulated and faithfully applied. For the millions of citizens who had faced obstacles to voting, the case represented something more immediate and personal: the fulfillment of the Constitution's promise that their voices matter, just as much as those of their fellow Americans who face no such barriers. As former Attorney General Eric Holder observed in a speech commemorating the decision's first anniversary, the Henderson County case reminds us that our Constitution is not self-executing. Its promises require dedicated advocates like Congresswoman Crockett, who insist that those promises be kept, and principled jurists like Chief Justice Roberts, who are willing to ensure that they are. The legacy of that extraordinary Supreme Court confrontation lives on in law school classrooms, where professors use the transcript to teach students about effective advocacy in courtrooms across the country, where advocates cite the Roberts-Crockett framework when challenging sophisticated forms of discrimination, and most importantly, in communities where citizens now find it easier to exercise their fundamental right to vote. For those who witnessed that remarkable day when Chief Justice Roberts acknowledged Congresswoman Crockett's exceptional advocacy with unmistakable respect, the memory serves as a gentle reminder that our system works best when brilliant minds engage with one another in good faith, guided by a shared commitment to constitutional principles and human dignity. The Henderson County case didn't resolve all the challenges facing American democracy. Of course, important questions about voting rights, election administration, and constitutional interpretation remain. But it demonstrated that progress is possible when we approach these questions with intellectual honesty, mutual respect, and a genuine commitment to the Constitution's deepest values. In a nation often divided by partisan rancor, the Roberts-Crockett exchange offered a glimpse of a different path, one where principal disagreement need not preclude mutual respect, where constitutional advocacy can illuminate rather than inflame, and where our highest court can fulfill its essential role as guardian of rights that belong to all Americans regardless of race, place, or circumstance. If this story of constitutional principle, brilliant advocacy, and judicial integrity moved you, please take a moment to like and subscribe to our channel. We're dedicated to bringing you thoughtful coverage of the moments that shape our constitutional democracy. Share this video with friends and family who might need a reminder that even in challenging times, our system can still work as intended when guided by people of principle and goodwill.